Wow,
There are 4 other, as a matter of fact, Dennis and Hope. Rather than the link, Dale, have them just
Yeah.
go to the Zoom website.
Say
Go
it-
to
say
the
it
Zoom
again.
website and say, join a meeting, and manually type in the meeting ID.
Okay, and the meeting ID, I'll give you, Steve, is 897,
No, 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 no.
no? Oh, that's a different one.
Yeah, I can say it out loud.
Okay,
810 8259 6280.
did you get that, Steve?
Yeah, and is the password 4402?
Correct.
Yes. Yeah,
Okay, that the link that Rob Jamison sent me was different. I
Okay,
think.
as long as we get you in.
Yeah,
I'll stay on with you until you get in. Let me know when you're in.
Dale, let me give you my my number as well if he needs to get in touch with me. I'll chat it over to you. This is direct to my line at my desk. If he needs to call me directly, I can help out in that way also.
Okay,
says the host has another meeting in progress.
the host has another meeting in progress?
That's what it says.
Okay. Hold on 1 second, please. This is the only meeting I have in progress, but I will help you out, Mr. Byron.
Thank you so much.
Of course.
Christy, would it work if I just send him the Zoom email?
No, because your link is unique
Okay.
to you.
All right. I
I'm
don't know why. there's-
going to. Give me a moment to look up some information.
Hi, Julie.
I'm trying to get out of the light.
You know, I think other people may be having an issue, although Steve Patton is on, Steve Byron.
All
But-
right.
I am.
No, but I know that Rob Dubiak's trying to get on and I don't see his name up
Okay,
there.
here's I'm going to give you,
Hi, Jan.
do this one, Dale. See on the chat screen?
Yeah,
Try that ID.
okay, 897 5525 2196.
Try that one.
Got it.
You got it?
There we go.
Okay,
There you go. Byron's in, yeah.
okay, yeah, I can hear the echo, so I know you're in.
Yep.
Little feedback.
Yeah, he's gone.
Okay, Erin,
Yes.
we're recording, we're on YouTube and we're broadcast, so you can start the meeting.
I love it. It is Thursday, August 6th at 7:04 p.m. and I call the special meeting of council to order. First, Rob, can you do the roll call, please?
Sure. Rocky,
You're muted.
Rocky, DiBernardo,
Here.
Krug,
Here.
Evans,
Here.
Newell,
Here.
Rogoff,
Here.
and Wyval.
Okay. Thanks, Rob. So thank you everyone for joining us tonight. Tonight we're hearing an appeal of a decision from the Board of Zoning Appeals upholding a planning and zoning decision to allow a lot consolidation on Soul Leather Lane, which resulted in non-conforming lot. Briefly, just to give a quick rundown, here, what we're going to do tonight is Mr. Jameson's going to give us a walkthrough of the questions before us. We'll start then with the Gumbrick team and take testimony from anyone in the audience who is also asking us to overturn the BZA decision. Then we're going to pass it over to Mr. Marino's team, and after which we will take any testimony from anyone asking us to uphold the BZA decision. Mr. Markowitz is going to weigh in. We'll do some question and answer. And that's kind of our conversation. Just as a reminder, this is a public hearing. So before speaking, please state your name and your address for the record. And in order to keep things moving tonight, we are going to ask that all comments be kept to 5 minutes. And then Mrs. Holmes will be helping us with the timer on that one. So on that note, Mr. Jameson, can you kick us off?
Sure. The original application was received by the village from Dennis Marino on November 25th, 2019 to consolidate 2 small parcels of land within the Soul Leather Lane subdivision, along with a third portion of a parcel to be purchased and split off from the parcel of land at 136 West Summit Street. The request was to consolidate all 3 parcels and make it a suitable site for building a new home. The zoning review was performed on that, and the consolidated parcel would not comply with section 1125.03 of the zoning code pertaining to a minimum required lot depth of 160 feet in the R1 100 zoning district. The proposed lot would have a mean lot depth of 100.13 feet, which is 59.87 feet under the required minimum lot depth. Under section 1109.05B2, this matter went before the Planning and Zoning Commission on May 18th, 2020, with a request to modify the original subdivision plat to allow this non-conforming lot and to approve the non-conformity. That motion was approved with a 3-2 vote. Then that matter was appealed by the Hope Gumbrick and Rogers to the Board of Zoning Appeals on June 23, 2020. And that motion was discussed by BZA, and that motion to overturn failed with a 5-0 vote. After that, 3 council persons petitioned the village administration to have the decision of the Board of Zoning Appeals reviewed by council, which resulted in the hearing tonight. Public notices were sent per the requirements of the code. Further materials for tonight's meeting have since been received and distributed to all of council from both Steve Byron and Dennis Marino. So tonight, as we go through this, I have the original application. I have site plans and documents showing the proposed consolidation. I have the letters from both Steve Byron and Dennis Marino and other supporting documentation to bring up on the screen as needed. So just indicate that. I'll bring it up as we see fit.
Great, thank you. Okay, Mr. Markowitz, anything to add before we go on?
No, just that the process for testimony will be each person that wants to speak either for or against. I'll swear them in individually before they start speaking.
Okay,
And
perfect.
if they've blocked their video, if they could start their video when they want to speak so that we can see who they are and verify that they're being sworn in, that would be appreciated.
Okay. On that note, Ms. Gumbrick. Can we, I think we're going to bring in Steve Byron.
I am doing so now.
Okay, thanks, Christy.
Erin, who should I invite on right now in addition to Ms. Gumbrick?
Steve Byron,
Thank you.
probably Steve Patton,
Okay.
I assume.
Well, this is Steve Byron. Am I on? Do I need video?
We need.
We can hear you. We don't
There we
see
go.
you. There
How's
we
that?
go.
If I may, Dale, are you going to swear me in even if I'm just making arguments, not
No.
testify?
No.
Okay. And just to confirm with all of council, You folks have all received the correspondence that I sent on July 30th.
Yep.
And have had the opportunity to review that. Appellant's argument is strictly one of law. There is no authority for the Planning and Zoning Commission to grant a variance from the lot depth requirement. You heard Mr. Jameson say that the lot is not sufficiently deep. The appropriate procedure under your code should be that the Planning Commission denies the lot split and consolidation, then it goes to the Board of Zoning Appeals to consider a variance under the standards. This is a clear case. I strongly request council to reverse the matter and send it back to the Planning and Zoning Commission so that they can do their job to deny the request, and it can go to the Board of Zoning. I assume that the property owners would have the matter go to the Board of Zoning Appeals to be considered for a variance.
Okay. Anything else for Mr. Byron? Do we want to ask questions now, or should we wait for questions, Dale?
Happy to answer any questions if anybody has any.
Yeah, I would say take the questions now.
Council, do we have any questions for Mr. Byron? No? Nope, silence. Okay. No questions right now?
Aaron, I'm
Does-
assuming we're not taking questions or comments from attendees, only panelists at this time, correct?
Yeah, because it's a
Thank you.
hearing.
Okay.
Okay, in that case, do we have anyone else speaking for the overturn of the BZA decision who would like to speak?
They should raise their hand.
Sorry, yes, please raise your
Um,
hand and we can
They
bring you
have
in.
to,
We do
I
have a
have
One
raised hand.
attendee. I'm promoting Mr. Dubiak. If you could be sworn in by Dale, please.
I assume he's not going to give testimony either. He's just making legal argument. Am I correct, Mr. Dubiak?
Correct.
Hi, Rob.
Okay.
Hey, Steve. My name is Rob Dubiak from the law firm of Dubiak Nelson, and I am here on behalf of Mr. Marino. Just by way of background for council's benefit, when Mr. Marino originally went to the village to address the lot consolidation issue, it was determined, and he was advised by Mr. Jameson, that there was no variance to seek, or he could not go to seek a variance of the back depth because he didn't have a lot. And under section 1111, you can only go to seek a variance if you have a lot of record. So procedurally, what Mr. Marino has to do under the code is go to Planning and Zoning Commission to seek the lot consolidation, which is what he did, and which is what Planning and Zoning granted, and that was the consolidation of the 3 lots. So our contention is that by granting the lot consolidation, it ultimately had the effect of modifying the depth requirements such that no variance was needed as part of the process. And pursuant to 116105, the Planning and Zoning Commission clearly has the ability to make determinations as to the lot depth, which they did in their decision. That decision to consolidate in the subsequent modification or the simultaneous modification was approved by Planning and Zoning Commission in a 3-2 vote. That decision was appealed to BZA. BZA in a 5-0 vote affirmed that decision, and the variance issue was never raised at either commission or BZA and city, and it's being raised here for the first time for council. So we believe that planning and zoning did do the proper review and analysis and came to a decision that did modify it in accordance with the Chagrin Falls zoning code.
Okay. Do we have any questions for Mr. Dubiak, please, from council? Love hearings. Okay. I don't think we have any questions for you quite yet. Okay. Do we have anyone else who wishes to testify? You can raise your hand or offer testimony, I suppose would be the correct phrase. Any hands? Give them a second.
No
Aaron,
hands.
it might be helpful to explain to people if they want to raise their hand, there's an option depending on whether they're on a computer or an iPad. The iPad, it's in the upper right-hand corner. They would click on more and they'd find it there. If they're in their computer, let me see where it is. It is.
Thank you. I'm not familiar with the hand raising function since I'm not usually on the back of the panel.
It would be under chat, which is in the middle on the bottom. There would be an option. No, it's not there. Oh, it's under Q&A, I guess. Huh. I usually do it on my iPad, but there does not seem to be any. Christy, you don't have anybody interested in speaking, is that correct?
That's correct.
Okay.
Hey,
On that note,
this is Hilda. Can I speak briefly? Okay, my comment.
Wait a minute.
Hold on.
Wait.
I have to swear in.
Yes.
Yes. Okay, you solemnly swear the testimony you'll give will be the truth, the whole truth, and nothing but the truth?
I do so, God.
Thank you.
Okay, just from my perspective and my husband's perspective of this, the original denial from the village was supposed to go to the BZA back in March, and then when everything was shut down with the COVID outbreak, it was canceled. When it was rescheduled, it came back to planning and zoning. And just as, you know, the property owner with the objection to this and not clear, it was really confusing. So the whole procedure and process for us has been confusing. When we went to appeal it, we were imagining that we would have a chance to address the factors that are to be considered in granting a variance in a more organized structure like BZA typically does. So that is how we ended up at this point. I hope that kind of helps to clarify how we got here from our point of view. Thank you.
Appreciate that.
Could you please state your name and address for the record? I don't know.
Absolutely. Hope Gomprecht Rogers. I reside at 68 West Summit, and my husband owned 120 West Summit. That's where I grew up. It's contiguous with our current residence.
Thank you.
Thank you.
Okay, Mr. Markowitz.
Okay, well, this is an unusual hearing because this is not really a factual type of hearing that you're used to. It's not an appeal from the BZA that you're typically used to, where there would be some variance either granted or denied, and you're being asked to review what they did. In this hearing, the applicant as well as the appellant are essentially arguing that there are issues of interpretation of our zoning code, or really issues that are legal arguments that need to be decided by the board. If I can distill the arguments by both sides in the simplest forms, the appellant, through Mr. Byron's brief and his statements tonight, he is saying that the Planning and Zoning Commission does not have the power to approve a lot consolidation that results in not meeting the lot depth of 160 feet, and that only the Board of Zoning Appeals would have that power. Mr. Dubiak, if I understand his argument, is saying that the Planning and Zoning Commission, in having the power to modify the lot width to depth ratio was allowed to create a lot that would become non-conforming upon their modification, and that the 160-foot depth would not be required to be met, because they would have the ability to, in essence, create a non-conforming lot through their actions under Chapter 1161 of our subdivision regulations. Before I go into my opinion on that, if anybody has any questions on council that you want me to ask, and I see Julie Lindner's on the meeting also. If there's any questions you have for her or myself, we'd be happy to entertain them. I will tell you that Rob Jameson and Julie Lindner and I all looked at this a number of times throughout the process, and I can appreciate what Mrs. Gumbrecht Rogers is saying. It wasn't easy for us to figure out how to use this one, because we're talking about altering a lot of record in a platted subdivision, which has statutory procedures as to how that has to be accomplished. It also had consolidation of a lot that was not part of the subdivision with land that's in the subdivision. And then you had a need to meet lot to width depth ratios and lot depths that didn't meet either our subdivision regulations or our zoning code. And so we sent it to the Planning Commission first to consider the modification of the lot width to depth ratio, and the Planning and Zoning Commission granted that. The question ultimately for you to consider then is, should they have conditioned their approval on the Board of Zoning Appeals granting a lot depth variance? Or did they have the power to grant the modification and consolidation and therefore not have to comply with the lot depth requirement?
Can I ask a question?
Is that Steve Byron?
Yeah, I obviously just did ask a question. Am I permitted to ask a question?
It's okay with me.
Yeah, the lot depth ratio is in the subdivision regulations, and you would think would come up in the context of a change to the subdivision. But this is a lot split and consolidation ahead of that. And so I'm wondering if that procedure of having the Planning and Zoning Commission look at that issue and de facto grant a variance to the lot depth requirement is the proper procedure.
Yeah, I have some more to say about the zoning and the subdivision regulations, but before I got there, I wanted to know if council has any questions that they want to delve into.
Guys, how are you feeling? Are you clear so far?
No, I need to hear more.
Okay.
Go for it, guys.
I'm going to be turning my head, but not to look at the Indians, who, by the way, are winning 1-0.
Oh, good.
I'm going to look at some code sections that I put together for the purpose of the meeting tonight. The subdivision regulations, by the way, are not part of the Planning and Zoning Code. They are a separate set of regulations. The process for adopting those and adopting improvement standards is through Chapter 711. The zoning code is adopted through Chapter 713 of the Ohio Revised Code. And in the subdivision regulations, and this is something that was cited by Mr. Byron, is there a provision in 1161.02B that says that whenever the requirements of this regulation do not agree with the requirements of any other lawfully adopted law, ordinance, regulation, resolution, or rule, the more restrictive or that imposing the higher standards shall govern. Now, taking that argument to its ultimate refinement, I don't believe that's the right section to cite, because I don't believe that the subdivision regulations conflict with the zoning code. However, the reason why I say that is that, as Mr. Byron stated before, the lot width to depth ratio and the ability to grant modifications does apply to certain elements that could be part of the zoning setback requirements, but the lot depth is not one of them. So I don't see where there would be a conflict here. But where I then next look is in section 116105, that the design standards for subdivision lots provides in H that the lot size, width, depth, and the minimum building setback lines shall meet at a minimum the existing zoning regulations, except where the commission and village engineer determine the hillside protection regulations apply. And the engineer has told us they do not apply here. So I then look at the zoning code because I can't find anything else in the subdivision regulations that cover this. And I find in 1105.02 B, I'm sorry, 110504B, it says, and this has to do with applications and jurisdiction of the zoning code. The provisions of this planning and zoning code shall be considered as minimum requirements and shall be liberally construed to further its underlying purposes and objectives. They shall apply uniformly to each class or kind of building, structure, or land. Where the provisions of this planning and zoning code impose greater restrictions upon building, structures, uses, or land than imposed or required by other codes, laws, ordinance, rules, regulations, or restrictive covenants running with the land, this planning and zoning code shall govern, and conversely, other regulations shall govern where they are more restrictive than this planning and zoning code. So what that means is, if the interpretation of the subdivision regulations was that the Planning and Zoning Commission could grant modifications that would allow for less restrictive development of a lot, in other words, a lot depth wouldn't have to be 160 feet. This code section says you can't do that, and that the zoning code would prevail. There's another section, 1105.06B, which says where this planning and zoning code is more restrictive as to the use of structures, buildings, or land, and/or limits the height or bulk of buildings, or requires larger areas and yards than are required by other deed or plat restrictions, codes, laws, ordinance, rules, or regulations, this planning and zoning code shall govern, and conversely, other regulations shall govern where they are more restrictive in nature than this planning and zoning code. So it's similar to what was in 1105.04B, but I think even more concise. Having said a lot of words here, what I'm saying to you is that I believe that when the Planning and Zoning Commission approved the lot modification, it could not result in the lot depth not being met. And they had to either, the property owner had to appeal to the Board of Zoning Appeals to grant a variance before Planning and Zoning Commission granted the modification, or the Planning and Zoning Commission, which is typically what we've been doing, they could grant the modifications and the lot consolidation conditioned upon the Board of Zoning Appeals granting the lot depth variance. And if they didn't, then the lot consolidation and modification would be a nullity. If they did, then the lot reconfiguration would be approved, assuming there were no appeals.
Okay. That's a lot of words. The last part really did make sense, though. I appreciate you breaking it down
Thanks.
for us.
Okay.
Do we have any questions for Dale, Mr. Dubiak, or Mr. Byron at this point?
Yeah, I have a question. Dale, what does the end of your summation helped a lot. you said that the proper procedure should have been, well, the P and Z board really did not have the authority to send this or to approve the lot consolidation because of the depth, and it should have gone to BZA for a variance before they did the lot consolidation. Is that what I heard you say?
Well, no, they had two options. They either could send it to the BZA first and then have it come back to them to rule, or they could approve the
Okay,
consolidation subject to BZA granting the lot depth variance.
right. And what process was followed?
Sorry, I didn't quite catch that.
Remember I told you you come in the loudest and clearest? Alexa
me?
thought you were talking to, yeah.
I didn't get that. Could you try again?
Alexa, quiet.
I didn't get that.
I'll
The,
whisper.
Okay, I'm gonna.
The chair,
Hit do not
the chair-
disturb, yeah.
The
Hit the do
chair
not
could
disturb.
rule Alexa out of order.
Exactly.
I know, right?
Removed from the meeting.
I don't have a gavel though, so sorry.
I just
go.
took all our power away.
Oh, there you go.
Okay. I gotta admit, I forgot what you were just asking me.
What procedure was followed? Did
Oh.
it go to BZA for, okay,
It did not. And that's when we were at the BZA, because the appellants here appealed the decision of the Planning and Zoning Commission to the Board of Zoning Appeals. At that point, that's probably where we should have said, you know what, we should be here for a different reason. We should be here for the variance on the lot depth. And that's where administration and the law director missed it.
So
Okay.
the best way to clean this up essentially is to go back to planning and zoning, have them give a conditional approval based upon a variance to be issued by BZA, like very bluntly and shortly,
assuming they would grant approval.
assuming people voted.
And have them consider the variance. Yeah, exactly.
And then have
They-
BZA consider the variance.
Right.
Thank
What you'd be doing is you'd be reversing the zoning board of appeals and remanding it to the Planning and Zoning Commission to reconsider the lot modifications and lot consolidation, and that they couldn't give final approval until they refer it to the Board of Zoning Appeals for the variance on the lot depth.
So for council, do we have any other questions before we move to any motions? Because I just want to make
No,
sure.
it's-
an opportunity to ask a
Well,
question.
Mr. Dubiak had a comment he wanted to make.
Okay. Mr. Dubiak?
The only comment I wanted to make, Mr. Markowitz, was the fact that the planning and zoning decision was made and BZA approved it. Is it appropriate to now reconsider both of those decisions at this stage in the game?
Well, the the Planning and Zoning Commission could just go back and say, well, we've already approved the modification. We will modify our modification to say that it's approved subject to the Board of Zoning Appeals approval of the variance. I don't believe they have to rehear the modification issue unless they choose to.
If I could be heard on this point, I think the fact that the administration had been suggesting that this was an appropriate procedure, and obviously the current appellants were not represented by counsel at the time, precluded them from being able to make the argument at the appropriate time. They were being advised that because there was as Ms. Gumprecht said, they had been advised that the Planning and Zoning Commission would be denying it and the issue would be going up on a variance. And so that's all that we're requesting that be done at this point, is that the initial advice to the opponents to the lot split be given the ability to make their arguments at the appropriate time at the BZA level. The way it happened, they didn't get to make the arguments on whether or not a variance was appropriate. as they thought they would have been. So that's all.
And if I could just comment on that, this is appellant's appeal, and whether or not appellant was represented by counsel, and I don't believe counsel appeared, but I believe they were represented by counsel at the BZA hearing. Putting that aside, it was their appeal at BZA. They did not raise this challenge or this issue. So I would contend that they waived the issue and they now can't appeal the BZA decision to counsel on grounds that they never have raised previously.
Those rules are applicable in court. They are not applicable in administrative proceedings in front of municipalities.
Dale?
Yes, exactly.
Well, the way I interpret our rules, and this, I don't necessarily disagree with either Mr. Byron or Mr. Dubiak. It depends on what the codes provide in each community. Because we have this petition process and you can present a second appeal administratively, I don't view that as waiving the right in front of council to make the argument that there was no jurisdiction at the first level. So I would say that I believe that you have the ability to consider the jurisdiction and the power of the Planning and Zoning Commission to act in the first instance.
And if I could add, as Dale knows, jurisdictional issues can be raised at any time in a proceeding. And that's exactly what we're doing here, raising the issue of the jurisdiction of the Planning and Zoning Commission to grant a variance.
If council didn't feel like they were judges and lawyers before this, I'm sure they do.
Okay. So lots of arguments before us. Council questions. I want to make sure everyone's as clear as we can possibly be given the waters we swim in. Friends, okay. So we're going to attempt a motion here. Ready? Okay. My feeling is that we've gotten some advice from our village lawyer and we should heed his advice. So I would move to reverse the decision of the Board of Zoning Appeals, vacate the decision of Planning and Zoning Commission, and direct the Planning and Zoning Commission to revisit the matter and condition any re-subdivision and lot consolidation approval with any required modification by the Planning and Zoning Commission on the original applicant receiving any needed variances for consolidating lots and re-subdividing the land from the Board of Zoning Appeals.
Second.
Is that clear? So motion by group.
Can I say something? You went in and out a little bit, and I'm not sure Christy got it all. You might need to say it all again.
Do you want me to re-say it all?
Yeah.
I think it might be worth it for the record.
Okay.
Sorry, Erin.
I do have this in writing and I will send it to expedite the process of the minutes. I move to reverse the decision of the Board of Zoning Appeals, vacate the decision of Planning and Zoning Commission, and direct Planning and Zoning Commission to revisit the matter and condition any re-subdivision and lot consolidation approval with any required modification by the Planning and Zoning Commission on the original applicant receiving any needed variances for consolidating lots and re-subdividing the land from the Board of Zoning Appeals.
And that was second by
That was,
Mr. DiBernardo.
yeah, so we have a motion by group, second by DiBernardo. Roll call, please. Oh, do we have discussion before we? No, friends? Okay, go ahead, Rob.
If I could ask Mr. Markowitz a question, is based on your comments earlier, is that the appropriate motion, or is it to make the Planning and Zoning Commission lot consolidation determination subject to the review by BZA of the variance request?
I think that is a motion.
I believe the motion is asking or directing it to be sent to Planning and Zoning first for a redetermination and then to BZA.
Correct.
Where I thought, you know,
It's
not that I want this to happen, but the alternative would be to send it to BZA in light of the Planning and Zoning decision for consolidation.
But it's one half dozen one way or the other, isn't it? Like, as long as the variance is given before final approval.
I don't see this going back to the BZA.
No, what my point, no, to clarify, my point was planning and zoning has considered and approved the lot consolidation request. You're saying, I believe what you're saying is it should have been then subject to a subsequent determination by BZA as to the variance request. So my only question, or my question to you is, if planning and zoning has approved the lot consolidation request, isn't the proper procedural?
But their approval was
to-
not conditional upon the BZA. So
Right.
I don't think we can tell them that their approval is now conditional upon the variance because it's a different motion than the one that was made. But I didn't go to law school, so maybe I should be quiet.
No, I agree with Aaron here. I think Planning and Zoning Commission has to decide whether they want to defer to BZA first or whether they want to act first. And I don't want to get it overly hung up on this point, other than to say that I believe that the motion is to send it back to Planning and Zoning Commission. If you were to send it to BZA, there's no variance application pending in front of them. So you've got to do some process to get it back to them.
Right.
That's why I would say it's got to go to the Planning and Zoning Commission. They act in whichever way they want. And then assuming that that lot depth variance is still needed, then the property owner would submit an application for variance to the BZA.
So we have a motion on the floor and we've done the roll call. So I'd like to go forward and get the vote done, just to follow some level of, meeting rules.
We do have a hand raised. I don't know how to handle that. Should we vote first or
I
no?
know, I don't know either. Dale, we have a motion, we called for the roll, like. I
Yeah,
don't-
Louis Marino wants to speak. Unless he was denied the opportunity to speak before.
No, he was present during the time before where we offered.
We should vote first and that's it.
I don't know
It's
what-
your discretion. You have the discretion either to let him speak or to vote, whatever you prefer. It's President of Council, your call.
Guys, are you,
Let him speak.
why don't we let him speak? I don't want to
Yes,
get the
yes.
motion, but okay.
Aaron, would you like to stick to the 5-minute?
Yeah, we
time
still,
for
yeah, he
person
needs to-
speaking?
if they believe he needs to be sworn in by Dale, we need the name and address for the record, and we need to keep it to 5 minutes.
Yeah, is Mr. Marino on a telephone or is he on? I'm not
He just-
seeing him.
I'm
It
working
just
on it.
appeared on
Hold
the
on.
screen, yeah.
I mean, I see his name and that he's muted, but can't tell whether he's by phone or by Zoom. Or I should say, video.
It
I don't think we can
appears to
tell,
be through some sort of device. Although I'm requesting that he unmute, but he's
There
not
he is.
doing
There it
so.
is. Okay, there we go.
Okay,
He has not unmuted yet.
There you go. Shine
we're
a light.
working on this.
Mr. Marino, hold on, we can't hear you quite yet. Christy's gonna send you a little box that's gonna say,
Yeah, yeah, yeah.
please unmute yourself. Just click yes.
There you go. Good.
There we go, go ahead.
Before you speak, are you trying to testify or is there just some question or?
Well, I suppose I'm testifying, yes. Yes, I suppose I am. It's a little,
So if you are, then counsel, you have to decide whether you're gonna allow him to testify and reopen the case.
well, excuse me, but this is after the motion has been made and seconded, there's room for discussion, and I'd like to be in that discussion period.
Well, that room is between the council members, not somebody who wants to testify. Madam President, if you're going to have a vote of council if you want to allow new testimony.
Well, whatever it takes, I would like to just make
Okay.
a little
So do we
statement
need to
here.
make hold on, Mr. Marino, do we need to make a motion then to allow for additional testimony?
Yes.
So what happens to the motion that's on the floor? Do Should we just pretend it's not there?
No, you,
Robert's rules didn't cover this.
no, it's still on the floor.
Okay.
Okay, so I would motion to allow Mr. Marino to testify at this point in our hearing.
Second.
Motion by Group, second by Rogoff. Roll call, please, on the motion to allow additional testimony.
DiBernardo,
Aye.
Evans,
Aye.
Groove,
Aye.
Newell,
Aye.
Rocky,
Rocky's still muted.
Okay.
Got it.
May I
And
speak
Rogoff.
now? May I speak now?
Oh, hold on, Mr. Marino.
Rogoff,
Okay.
Aye.
Okay, now before you speak, I need to swear you in. If you'd raise your right hand, please. Do you solemnly swear that the testimony you'll give to the council tonight will be the truth, the whole truth, and nothing but the truth?
I saw you, Ms. Reno, but I need you to unmute one more time. Unmute your computer, please. There you go.
We all set now?
Yes.
Okay. I'm gonna just thank you for this opportunity for me to speak here tonight. I know what you guys are being through. Then I was on council for 6 years back when I lived in Chagrin Falls. But I said we have waited patiently and followed the correct village procedures for this proposal. And it has been approved by the Planning and Zoning and reviewed by the Board of Appeals. And it's not a major development. It has no impact on the environment. It is not increasing any density. It is simply a plan to add another quality home to the already quality street in the village. I would like to state clearly that I hope you can see through the Gumprecht and Rogers charade that there are no zoning problems. There are no drainage problems. There's simply, it's a not in my backyard argument. The zoning issues have been approved by the Planning and Zoning. The drainage issue has been approved by the village engineer. Questioning the procedure of the system is simply another attempt to put a roadblock in this legal process that have been followed and approved. I just don't understand their motive, since there's no way a new upscale residence will have any financial or view impact on their home. They may have their own motive of planning to develop their property into a new development of their own. So why the big fuss? Why hire a lawyer? I suggest that you consider that this complaint is not what they have purported to do, but I suspect there's more to it. I cannot say for sure what their motive is, but I would question these objections and move on. Thank you.
Thanks for joining us tonight, Mr. Marino. Do we have any questions for Mr. Marino before we? Dale?
We also have to allow the audience to examine him if they so elect.
Oh, yes. I'm sorry. Would the audience like to examine Mr. Marino? Thank you.
I have no questions for him.
Okay. Okay, so we have a motion on the floor. Do I need to remake the motion, or are we clear on where we're at?
I believe the motion is clear.
Okay.
And it's been seconded.
Yes. Rob, can you do the roll call, please?
sure. Rogoff,
No.
Rocky,
We can't hear you, Andrew.
Okay, one quick question. If I vote yes, we're overturning the planning and zoning decision, or the BZA decision, which overturns the planning and zoning, correct? If I
Correct.
vote no, okay. So I'm gonna vote yes based on the fact that that there was an overstep and an oversight by the planning and zoning because they couldn't grant a lot merger with a variance without sending it to BZA first.
Newell,
Aye.
Groove,
I'm going to vote yes, and I am just want to be clear that we're not, at no point are we sort of saying whether or not this house should or should not be built. We're simply talking about procedure, so yes.
Evans,
Yes.
and DiBernardo.
Yes.
Okay. Motion passes. The matter will go back to planning and zoning. Dale, I feel like you want to say this. Go ahead.
I do. Ordinarily, we'd be at the zoning board of appeals and Wade Frick and I would look at each other. And one of us would mention the 15-day rule, which doesn't apply here, but this will go back. This will go back to planning and zoning, subject, however, to the fact that an administrative appeal could be filed in the Court of Common Pleas for Cuyahoga County if somebody is unhappy with your decision tonight.
Okay.
Do we have to wait is there a certain amount of waiting time that has to be done? Or could we expect this to go immediately back to planning and zoning?
It needs to, right?
It can go back immediately to planning and zoning, and only if a stay is issued by some court, if an appeal were filed, would that stop the process.
Okay.
This is quite the process. Okay.
Yes.
On that note, thank you everybody for joining us tonight and for taking time out of this beautiful evening. We are adjourned at 7:50 and enjoy your night. Thanks.
Thank you.
Thank you.
Have a great evening.